Hello, everyone. I'm Steve Collins from Land Title America. Welcome to Land Title Talk, where we encourage you to text in with your questions or comments at 904-501-4481, 904-501-4481. You can also email those questions at Stephen, the biblical spelling, Stephen, S-T-E-P-H-E-N, at land, L-E-N-D, title, Title.com, where we can address your questions on air. Today, I'm with my fabulous attorney brother, J. Russell Collins, affectionately known as Rusty Law, and we're glad to have him here with us as always to be our expert know-it-all. Just ask him.
That's right.
And then we have Julie Suttle, who is here from Land Title. We appreciate her participation. She always keeps us in line when we decide to start talking about stuff that just isn't relevant. So, Rusty, what's going on in your world?
Well, I got an interesting case that I'm working where mom died and father owns the house. Father has a son and a grandson. The grandson is the child of the father's deceased daughter. Okay. And so father has his homestead. The son who recently had come home.
Grandson.
No, well, we got
Mother
who's passed away.
Father who's
kind of old and maybe not 100% mentally there all the time.
Has her homestead property. Okay, he has a daughter who's passed on.
Right.
And we have a grandson.
Well, yeah, so we have the son and the grandson.
We have a son and a grandson.
That's
gotcha.
Right. So the grandson's from the daughter.
Gotcha.
And so typically you'd have
if he died, it would be because we're assuming that the daughter had no other children.
That's correct.
Okay. And we're assuming the son's still alive. So we would have grandson and son as the heirs. Right. Gotcha. Okay.
So now son was recently released from being on vacation with the state.
The pink, no, the orange.
Yeah. Yeah,
vacation.
He had
orange is the only color.
Yeah, orange is the new black, I guess. Anyway, and that may or may not be actually relevant, but the
could be.
So, son thinks he's entitled to that house.
Well, did dad die?
Just no. Well, we're not yet.
Okay. Well then.
Okay. So how about this? Son gets off vacation like April 15th.
Which we mean prison, guys. Jail.
And then the mother dies either right before or right after that. Okay.
When he gets out of prison?
Right. Mom was sick and she passed away.
Okay, so he gets out of prison, mom dies.
Yeah. And then on May 1st, son gets a notary, has a durable power of attorney drafted, grabs a witness, and son's actually living in dad's house. Okay. Son and his wife are living in dad's house anyway, but they get the people there to sign a durable power of attorney.
So dad signs this.
Dad doesn't. He's got a really shaky hand, so he directs the son to sign for him as his proxy in front of the notary at dad's request.
Which that's a legal thing.
That document is executed and then it's recorded.
You didn't answer me. You didn't respond to my statement.
There's a reason.
Okay.
Okay. Son goes to getladybirddeednow.com, and that's a real website.
Gosh.
To have a ladybird deed drafted for way more than I charged to do them. But anyway,
you jealous or mad or what?
I don't know whether to be jealous or disgusted, but
okay.
Anyway, and then uses a mobile notary where he signs for his father as
POA
as attorney. In fact, and it's a ladybird deed to himself from his father.
Well, I just have to interrupt you just for 1 second. So my topic today happened to be on, and I didn't want to tell you that.
Oh, good.
So that's just interesting that our minds are aligned on this topic.
So the question, and then dad dies May 8th. So
okay. So wow, May 1st, mom dies?
No, April mom dies sometime in
Okay.
April.
Okay.
Dad signs the power of attorney, or excuse me, the power of attorney is executed on May 1st. The deed's done on May 2nd and recorded, and it's e-signed too. It's signed by using remote online notaries. And then
Yeah,
Dad
that's
dies
weird,
on
man.
May 8th.
Wow. Did anybody like check how he died by chance?
He wasn't well.
Okay.
Okay.
All right.
Mom and Dad both got really sick together, I guess.
Okay.
And then
They were
of
not
course,
apart for very long. That's sort of a romantic thing.
yeah, especially when you find out who I'm talking about. But anyway,
I know these people.
you know, at least the wife.
Okay.
Anyway,
By the way, is it that one there? Because maybe you did give me a heads up
Yeah.
about it. Oh, so I knew about this. I was going to talk about it today anyhow. So we're aligned on
We're
our
synced.
topic. Yeah, we're synced. Okay.
That's scary. Anyway, and then after Dad dies, son does a quitclaim deed prepared by a local law firm, not mine, to him and his wife.
Okay.
Okay. Now, I think there's several things wrong with this because, see, grandson got taken out of his inheritance, right? He would have had half the house.
But father has every right, or grandfather has every right to make that decision.
Of course. But is the power of attorney any good?
Well, I don't know if I question the power of attorney. If you have a notary, and gosh, and I hate being wrong on this because this is something I should know, but you're there and the person cannot sign, okay? And they direct somebody, the notary witnesses this.
Okay, no. See, the statute allows the notary to sign for the person.
It's the flip.
But there must be two witnesses too. Okay.
Right.
So the notary couldn't be the
That's
witness and the
right.
notary, but the notary can sign for the person. There's special jurat language. Okay.
That's
used.
right. It can't be the son that's got to do it. It's got to be the notary. So actually, the power of attorney was void.
It was never. Yeah, it was never any good. Okay. And believe me, you can tell who signed it because the son.
Well, I'm sure the son's not going to perjure himself. I mean, obviously.
Well,
and the notary's not going to perjure themselves. They're all going to be deposed.
Well, probably, but the bottom line is, the son's admitted that he signed at his dad's request.
Right.
Okay.
But the note, but here's
the thing.
I mean, I can see how that mistake can be made because I mean, I just told you I thought the notary could direct. I mean, as long as the notary witness, but the statute says the notary can sign on behalf of.
Right. There's a provision for that.
Right.
So, and you can
I knew it was
tell
something like that.
The son's marriage license is on record in the public records, so you can see in his name and his father's name, he has a middle name. His father didn't ever use a middle name, but if you just took the middle name out of his signature on that marriage license, it is ridiculously the same.
What? But he admitted to it. So
right, but you
you
still
don't have to prove it.
Right.
He admitted to it.
Right. So, bottom line is that deed no good. No, Ladybird deed's no good. And
Well, but see,
no
the
good.
Ladybird would be no good for us. Well, I shouldn't say no good for us. We title people don't like to or won't insure self-serving deeds.
Well, here's the other thing.
Where you use the power of attorney to convey property to yourself.
Well, there's a provision in the, assuming that power of attorney was valid.
Okay, let's go with it. The power of attorney is valid.
So first of all, self-serving or you if you act as somebody's attorney, in fact, you're a fiduciary.
Correct.
Okay, so anything.
But we title people don't want to insure that.
Right. You're a fiduciary.
We find that to be a risky transaction where a power of attorney just takes it upon himself to sign as attorney in fact for the owner to themselves.
Right. And there's a provision in the power of attorney that the attorney in fact could use stuff for certain things, but signing a deed is not one of them.
Okay.
If you had to take money, and if you had if you had to get money out of the account to pay the light bill, and you're living in the house with dad,
of course,
okay, or to get food,
makes sense,
or something, things like that, that would be fine because the power of attorney specifically allows for it. But acting as a fiduciary and doing a deed to yourself is not a thing. You can't do that. Okay. The power of attorney cannot sign an affidavit on behalf of the person. They can't vote on behalf of the person. They can't perform personal services on the behalf of the person. Now, the powers of attorney do not give you the ability to do that.
You can sign affidavits.
Not based upon the person's knowledge.
No, but
You can sign an affidavit on the attorney fact can sign an affidavit on their own personal knowledge, but
Well, yes.
not on the
Right.
other person's knowledge.
or if we have a situation where we're trying to, the back chain of title has a question as to whether or not it was homestead property or whether or not they were continuously married, the power of attorney, the attorney in fact could sign on behalf of the seller
Well, anybody could sign on behalf
if they had knowledge.
if they have knowledge.
Right.
Okay, so that was an interesting. Now here's the other thing, though. I am told that the power of attorney may have been used to take money out of banks. Who has the liability for that?
Well, I don't think the banks do
Why?
because he had the power of attorney.
No
Those are the
good.
rights. Well, the bank doesn't know that. The bank has to rely on the face of the power of attorney, which was witnessed and notarized, right?
And that is the key. Okay. When we changed our Power of Attorney Act,
Okay, which was when? Do you remember?
2012 or 13.
Oh, that recent.
Yeah.
Okay.
Number one, we made it where you couldn't have springing powers of attorney. They're valid immediately. They can be used immediately. Okay. It used to be you could put a provision that says if I go loopy, it now springs into life. Okay.
Right.
Not now. And they can't do that. They're either good or they're not good.
Okay.
A copy is as good as an original.
Oh, did not know that.
Right. So, well, how many originals do you expect to have, and what do the banks want? They all want the original, right?
Me title guy wants an original.
Okay. So,
Okay.
how can you do that if you only have one original?
Record the sucker and get a certified copy.
Well, okay, but not everybody thinks about that.
Okay. Well, there's your answer though.
Right. Well, you don't have to do that now.
Yeah.
Okay. And there's certain wording that can be used in a power of attorney where you can initial next to it, and it kind of gives superpowers. Okay. And it really, what it does, because really the bank doesn't care. They just don't want to get sued, right?
Right.
Okay. So we protect the banks. So when I walk into a bank with a power of attorney, and I've done this, I had to go to the jail to get a lady to sign a power of attorney. So I could go to her bank, Wells Fargo, and get $10,000 to pay another attorney to represent her in a case.
But back to this story, the bank, I do not believe has any liability.
They're not liable because
right.
Again, what happens when you go into the bank to use a power of attorney? They're going to send it to the legal department, and the legal department is going to look at it for, does it give the powers?
Does it have all the elements?
If it has the elements, we don't really care because we're protected. That's the idea.
Right.
Okay.
So all the liability falls upon the son.
Right. And
if he's acting as a bad actor, then he has a liability.
Well, here's the interesting thing. He may not have realized that wasn't a way you could do it. Because here's the thing. The notary, she got dad's thumbprint on her.
But here's the problem.
Notary journal.
Rusty, when did he draw that money out of the account?
I think while daddy was alive. Now, he may have done some stuff with a debit card afterwards.
That power of attorney is void when he dies.
That power of attorney was never valid.
Okay. If it were valid
and
he dies, power of attorney ceases to exist.
Well, yeah, it's no longer valid, yeah.
No longer valid.
Yeah.
Okay. So if he went into that bank without disclosing to the bank that my father's dead.
Well, the money was taken out most likely beforehand.
For heaven's sakes, man, it was signed on the 1st.
He died on the 8th.
And he died on the 8th.
Right.
What are the, I mean,
you do it quick.
I'd like to know what day of the week was May 1st, 2025. Find that out for me. Don't you look. You're on the show. This is what Julie's here for.
Oh, okay. Slave work. Okay.
Yeah. Put Julie to work. Okay.
Okay. So anyway.
It was a Thursday.
It was a Thursday.
So think
Thursday
about that.
to Thursday.
Thursday, Friday, Saturday, Sunday.
Yeah.
Bank,
well, did he get to the bank that quick? I mean,
I'm sure he did.
Maybe.
Okay.
I mean, how much money are we talking about?
Probably significant for you and me.
Depending on the time of the month, that may be a different number.
Remember, depending, right, if you have Social Security type income and stuff, okay, then, depending on when you get it and what gets spent. But anyway, I've sued.
On behalf of the grandson.
On behalf of the grandson.
Okay.
To have the court declare that the power of attorney was no good, the deed's no good. And
what about the money?
that might be an issue for like a probate case when you get a personal representative and you find out from the banks.
It's homestead property, but I guess you still have a personal representative for the money.
Well, to do the money thing.
But the home is not going to go in.
Well, it'd be an order determining homestead. But here's the thing:
get 50%.
Right, but there might be some, adjustments for certain things.
Right,
because of where the money went.
You think the son's going to be cooperative?
Oh no, he's hired an attorney.
Okay,
so the same law firm that did the quitclaim deed. But you got to say they don't know.
Right.
Yeah. So
I'm gonna have to get some names from you. I know the person. I know the
family.
I know the family. Yeah, so I'm interested to know who the son and the grandson is.
So, anyhow, that's interestingly weird.
Well, it's a reminder of, when dealing with power of attorneys. I mean, for example, if you give somebody a power of attorney, there's some things that you need to be careful of you have the attorney in fact, you have the what's the word? Person who gives the powers. See, you had a brain fart too earlier.
Yeah, I the
person who signs the power of attorney is a
signer.
Oh no, that's not the word.
I don't know. It left my brain.
That did too. That's weird. What? It just is going to look it up. The person who signs the power of attorney, because we can't think of the freaking word. That person, when you give somebody a rights to sign on your behalf,
that's very powerful.
Very powerful. Principle. Oh my gosh. Could not think of the word to save my life. Boy, if my life were
if we had
in
the
jeopardy, I would have been dead.
It'd be great.
Yeah. So the principle, gosh, the principle, okay.
With an LE, not an AL.
Okay, the principle, right?
Mm-hmm. No, it's actually AL. Oh, right. Principle, yeah.
No. You're wrong 2 times in a row. Gosh. I'm going to record. I'm going to take this show. I'm going to put that on repeat. Rest was wrong twice in a row.
He once thought he was wrong, but he was mistaken.
Yes. So the principal has to be very careful. I mean, how many different power of attorneys do we have?
What do you mean?
Well, for me, what I care about, because I'm a dirt guy, right?
Mm-hmm. You care about certain language.
I insure real estate. So I want to see a power of attorney that's going to be stating that they have the right not only to sell,
but
convey.
Right. Selling a piece of property it gives you the right to sign a contract.
So, and we have people, I mean, timing on some of these things, most of my clients have power of attorneys because we're dealing with ailing parents.
Right.
Okay. So we have a parent who's ailing, right? Getting older in life, and they want to get that power of attorney done for convenience for the older parent.
But it's not only the convenience, okay? If we don't have a durable power of attorney.
And that's what I was getting at. Getting a durable family, I call it a durable family power of attorney. I don't know why I put that family there. A durable power of attorney is important.
Here's why.
It gives the attorney in fact to be able to act on behalf of the principal to continue to act, especially if they have a property they're trying to sell, divest of, or and that's very important to get those things done in a timely manner, because if you wait until mom's not coherent, I didn't say adjudicated incompetent, I said coherent,
right?
Okay, then I mean, you're in trouble. Well, you're not going to be able to. No notary is going to be able to notarize that document that person signs.
So here's the background. A power of attorney gives the attorney, in fact, the ability to do what that person could do. Plus, powers of attorney must be signed with the same formalities as the document you're going to sign for them.
And for us, we want it signed, witnessed, and notarized.
Well,
Two witnesses.
So if we're when you transfer a vehicle title, you don't need anything. When the person signs the vehicle title, they just sign it, right? We can take it to the DMV and transfer.
Right.
No notaries, no witnesses.
Right. So
the power of attorney for a vehicle title does not require witnesses or notaries. Okay? Simple, right? If you had to have something that was witnessed, then the power of attorney would need to be witnessed. If what you're signing for them requires a notary, then you'd have to have a notary.
So an interesting point is mortgages in the state of Florida do not require witnesses.
That's correct.
So if I had a power of attorney drawn up, signed, but not witnessed, they could use that power of attorney to sign a mortgage. However, they could not use that power of attorney to sign a deed because it does not have the witnesses.
Now, does that include something that has to be recorded, though?
Yes, because
Power of attorney.
witnesses
then
are
you
not.
wouldn't need it for a deed then.
You need witnesses for a deed. Bro.
Right, you need witnesses. Excuse me. You wouldn't need a notary for a deed then. A power of attorney for a deed, you wouldn't need a notary if that was the case.
No, you're messing with me here.
Because a deed is valid with witnesses.
It is valid with witnesses, but
can't
you're not
record it.
getting recorded.
Okay, but you're not recording a mortgage without it being notarized either.
So what you're telling me is that if I have a power of attorney, as long as I'm not recording the power of attorney.
As long as you're not recording the document that person's signing.
Okay.
Okay,
Got
now,
it.
I don't think
I
that's a good
understand what you're
idea.
saying.
Now,
I understand.
um,
Whatever the elements of the documents being signed, the power of attorney must match.
right. And of course, that's what now, and of course, it's only something that the person could sign if they were present. What if the person is loopy? They can't sign if they're present, can they?
Yeah, but if I have a durable family power
Well,
of attorney,
that's
durable power of attorney,
That's what durable power of attorneys come
right?
from, because
They survives their
being incompetent,
incompetent,
except if they're adjudicated incompetent.
right.
Okay, so when we have the elderly parent, okay, who's might have some issues, or maybe not, or before they have issues, we get the durable power of attorney. That way, somebody can sign for them if necessary, and we can also have it set up to where you put the original in a safe, and you give them copies that are not usable.
Well, you put on it. This is not usable.
Yeah.
Okay.
And that way it stays back. But
You don't have to worry about it being used.
until it's necessary. But that way I can give the person who would be the attorney, in fact, a copy. They just can't use it. But if they show up and say, "Look, Dad's gone loopy," and I believe them, I'll give it to them. Okay. So that makes it kind of like a springing power of attorney.
Right.
That it's valid sitting in my safe, but nobody has it.
Right.
Okay. And the alternative, here's why they're so important. The alternative is a guardianship. If Dad needs to sign something,
if
and he
Dad
can't
went
sign
loopy,
and doesn't
sorry
die,
for the poor terminology, loopy, but yeah,
that's
if Dad went loopy,
that's the kinder.
it is.
version.
If Dad goes loopy, and I don't have a durable power of attorney, I'm going to have to do a guardianship. And what does it take for a guardianship? Because all I know is they're painful.
Well, here, it's not cheap, okay, because there's lots of expenses involved. But what you're doing with a guardianship is you're turning an adult into a child.
Okay. Interesting.
Okay.
Yeah, that's true.
And where that person can't determine what they do with their stuff, they can't determine where they live. You can control what they eat. We're turning them into a child.
Wow.
And when we do that, here's where the expenses come in. We don't do that without due process. So they get notice, and they get opportunity to be heard, and they get an attorney that's paid for. Okay.
Oh, really? By who?
By the person trying to get guardianship.
Okay.
Okay. And
So you're trying to get guardianship, you're going to end up paying for two attorneys.
You've got to have, I think it's three separate professionals say that person's incompetent.
Okay.
Okay. So it might be a physical examination.
Well, and I'm glad
mental,
that's
right,
the way it works.
There's due
because
process. We're
you don't want a doctor and a some guy has a big estate and a doctor and a son get together. We're going to throw Dad down the,
we're going to make him incompetent.
We're going to make him loony.
Yeah.
Right. Those protections are
And then of
very
course
important.
there are requirements for the guardian to do certain things too. I mean,
right.
There's training, there's reporting, and annual reporting.
But all of that goes away if you have a durable family power of attorney, unless they are adjudicated incompetent.
Right. But you don't have to do it to take care of business. Our grandmother was very independent all of her life. Okay. And there came a time when she and her husband were not taking care of stuff like their house, or not just the house, but They were eating bad food.
Well, you heard of green eggs and ham?
Yeah, they had
I didn't
green eggs
realize
and ham.
that was
That's the real thing.
that's a real thing.
Yeah.
I was like, Grandma, that's not normal.
No.
No, that's just because it's got sugar in it. I'm like, oh my gosh.
Okay.
Do not eat that,
So,
please.
but we didn't do the guardianship, but we were able to prevail on them to go to a nursing home where they'd be
Right.
taken care of.
Right.
The-
They went willingly.
They did, but if they wouldn't have, we would have had to do the guardianship.
We would have had to in that case because they were not safe for their own
They were not safe. Okay. So again,
nor for the grandchildren.
there are times when a guardianship is absolutely necessary, but we sure like to prevent that as much as possible. Number one is a pain in the butt for everybody, and we're taking away somebody's rights. So, anyhow, that's
So let's
very
say
interesting what
you
happened.
give somebody a power of attorney, and we like very specific power of attorneys in our business.
well. There was a time that I believed that if we had a power of attorney for a real estate closing, and this is probably in the 90s and 80s,
Right.
um,
Because you've been in the business that long.
yeah, since '79.
Me too.
But the we wanted a power of attorney with the legal description for the property we're talking about.
Right.
So you're not going to be able to use a durable power of attorney, a general power of attorney, when that happens. Well,
I'm pretty sure that was English. Say that again.
okay, let me try it again. We wanted one specific to the transaction
Mm-hmm.
that was also durable,
Yes.
because all we had to do was make sure the person was not dead and not
And not adjudicated incompetent.
not having a guardianship filed.
Wait a minute. If you're adjudicated incompetent,
No.
power of attorney still goes away.
If you're adjudicated incompetent, it goes away. If a case is filed and opened on you, it
It
goes
goes away. Okay.
Now, if they say the person's not incompetent,
Okay,
it comes
gotcha.
back.
Understand.
It's only invalid during the time the person's incompetent.
Gotcha. Being challenged. Okay.
Okay? So we wanted that. And plus, we wanted them to always sign, John Doe is attorney in fact for John Smith. It with the lenders, they really wanted it, which was maddening. Okay?
Stupid.
The reality is, if I have a power of attorney for you,
You get to sign my name.
I don't even have to say Rusty for Stephen.
No.
I can just sign Stephen.
Yes.
I have the legal authority to sign Stephen.
Yes. We like to clarify
now,
what.
the
and then
notary can say, the notary needs to say
Right.
Rusty for Stephen.
Right.
Okay. But all I
As
really
attorney
need to
in
do, and if I was doing it and feeling that way at that time, if I was typing the document, I'd say Rusty for Stephen and the typing under the line.
But only make them sign Steve.
Yeah. I say, you can sign, I can sign my name.
Yeah, you can sign either.
I can sign my name, I can sign your name, or I can, in the time when you're forced to do it, sign that whole piece of nonsense.
By the way, I took a stand on this with a lender.
And did you prevail?
No.
Okay.
They made me go back and sign everything.
Yeah.
Yeah. I'm like, if it's typed underneath, you don't have to make these people sign all that crap. It's ridiculous. I'm the notary. They sign the name. I'm acknowledging that. Done. And then they reminded me of the golden rule.
Yeah, they make the rules.
Yeah, those who have the gold make the rules.
And there's a
Doesn't matter what I think.
And there's a closing protection letter
That says I'll do whatever they say, including take all my clothes off and run naked in the middle of US 1.
I want to see that one.
Yeah.
No, we don't.
No, we don't.
No, we don't.
I just want to record it for posterity.
But it's true. I mean, whatever they say, we got to do what they got to. Whatever they want us to do, we pretty much have to do it. That's what we agreed to do.
I
So
know.
yeah, I lost that battle, but I agree with you. You should only have to sign the name.
And the problem with that is those people who are not lawyers and whatever,
They're just checking boxes. They don't
they're
know.
checking boxes and they can't even listen to me.
But so, like I said, we like very specific power of attorneys. We love those. It's very clear. We like a termination date on those specific power of attorneys. Normally, it just makes it clean for us because then it's very specific. But if you
But
give
here's the thing. If they bring you a durable power of attorney
Mhm.
that's valid on its face and you don't accept it and something bad happens, like the deal's lost,
I'm liable.
you're liable.
Yeah.
Right. So that's the thing.
But it's got to say convey on that
Oh,
document.
it does. I'm
Okay?
saying
Or something
about,
that states
you can sign a
some
deed.
type of conveyance, signing a
You
deed.
can
'Cause I
sign a
can't-
deed or encumber a property or
Right.
sign a note. You don't
it
have
needs
to
to be
use
specific.
you don't have to use the word convey, but you can say sign a deed.
I mean, I love these power of attorneys that, basically give authorization to do everything, including fly to the moon
Right, but and with one place to initial.
with one place to initial.
Yeah, I don't like those.
No.
And I don't think those are.
You
I don't
like the
think they'll
ones
make
where they
it.
initial each paragraph?
The paragraphs that have the superpowers. Okay, but I don't.
I don't. I just want a signature line. Put all the guts in there, sign.
Well, there's certain places they need. There's special places, and that if you're trying to follow the statute exactly for things to be able to open up a trust,
Right.
okay, or to, open accounts, close accounts, not just sign on an account,
Right.
to do certain things, and the statute makes it pretty clear. And I just think the people who do the one initial says, if you want all of these A through Q, then this initial here. You don't have to initial all those other lines. I don't think those are valid.
What would you do in the case if you've given me a power of attorney, okay, for whatever reason, and you now want to revoke that power of attorney?
I have a 45 in my drawer.
That would work too. Besides the 45.
I would revoke it. The key to
But how do you do
revocation.
that?
Well, the key to revocation is you've got to give,
Because, I've got a very powerful document that I can run around town. You could tell me, don't use this, and I could be a bad actor.
Then
and
you would
start
be
taking.
thief at that point.
Yeah.
At that point,
But you've given me a license to be a thief.
No.
Yes, you
I've
have.
given you a license to work on my behalf.
You've given me a license to be a thief because I can go around to all the banks real quickly, take all your money, and go to Cayman Islands before you have a chance to put everybody on notice.
Right. So if you want to protect yourself, you take the power of attorney and you record it. That way you can revoke it, because
Once it's recorded, everybody's given public notice of it.
that's
And once you revoke it, then even the banks are considered to have notice.
everybody has notice.
So
when you
let's
record it.
you have a mayor's bank. They come to you and say, we need you to represent us, Rusty, because we have a principal of a power of attorney who revoked that power of attorney in the public records, but we didn't see that, but we let some guy come empty out his account. We want you to represent us to defend ourselves against that principal.
I'd say call your liability company.
There's no defense.
I don't
Would you
think
agree?
I do not believe that there's a defense.
Yeah,
I'm not that creative.
well.
This is not Boston Legal, where we do everything on emotion and throw all the rules out.
Right. But it's a very, power of attorney is a very scary thing. I'm getting to a point.
Well, they're not scary, but they are important.
They're
and they're
scary,
powerful.
dude. They're scary. You give somebody power, because we have people do this. I'm traveling. It's not convenient. I'll give Tom Smith a power of attorney because I don't want to be up in the mountains having to try to find a notary.
Do you have cell service? We can fix it with cell service.
But you get it, and they'll give people these power of attorneys. This is why I like very specific power of attorneys. You don't just pull one off the freaking online.
Well, I think you need to have
man.
counsel when you get it done.
I mean, can you not be very specific with that power of attorney?
Oh,
you have the authority to sign a deed in reference to this closing on this property with this legal description, nothing else.
And it automatically cancels at the end of the year.
And it automatically cancels when the transaction takes place or at this date.
That's fine, but that's not really good for estate planning.
It's not, but that's really
if
good
you're doing
for
pre-planning to go on a trip, okay, then that makes sense. That's perfectly fine. All right.
I mean, but we have clients just willy-nilly give power of attorneys because it's convenient.
It is.
And we're like, okay, well, here's what we have to have. And we have to have the language to convey. We got to, we want to have the cell. We want to have witnesses, a notary, and that kind of stuff. And they bring us these power of attorneys. And these freaking power of attorneys are almost like hell. I mean, they can unplug them or something. I mean, it's just like, it's got everything in it.
That's fine.
No, it's not.
But here's the thing: if they bring it to you to sign or to review,
no, I can't review it.
If the principal brings it to you to review,
I'm a title guy.
Right.
I can't represent them. I can't review it. I just have to make sure they can be used.
Are you willing to accept it? That's what you can review.
Yes.
And if you have an issue, what can you do? You say, I tell you what, I got an alternative for you. One that will accept. Because you have a form. I'm pretty sure every title company in town has a form that they'll accept.
We do.
Okay.
We're not really supposed to tell people what power of attorneys to use. You think what kind of liability we have for that?
The only question is, what power of attorney will you accept? Not which one they should use.
One that states powers.
One that does what you want to do.
Right.
Okay. I mean, it's your liability. It's your risk to determine whether you're going to accept it. But our general policy is we do want them to be usable. And then what kind of power of attorney where all these rules go out the window?
Oh, I'll tell you which one. Thank you for the quiz. I'm going to pass this one. A military power of attorney.
That's right.
Yes.
Under the United States Code.
Yes.
If you have
I almost failed that, but yes, go ahead.
A power of attorney that's acknowledged by an officer,
right,
of the one of the military services, and they use a specific form for the most part.
And even if they don't,
Yeah,
I pretty much have to accept it.
you have
That
to
sucker
accept
doesn't
it.
have to be
It
witnessed.
doesn't have to be witnessed, and the notary or the person taking acknowledgement is a military officer, and here's why: they could be in a combat zone for all we know.
Yeah.
Excuse me, if you'll please stop fighting right now.
Stop shooting. I
Stop
need to
shooting.
sign and witness
Yeah,
and
I need to
notarize
sign-
this.
yes.
Yeah.
Frankly, if I was on the other side, I'd be looking for those times when people aren't paying attention. So, and again, it's a federal problem if you don't take those, because
Yeah, we have to accept those.
that's very important, and for good reasons.
Right.
Again, what we really want is finality in our contracts and in our execution of documents. So we're providing a way to where if somebody brings you a durable power of attorney that's properly executed, that has the powers on it, and you accept it, and it is a fraud, you're protected.
Right. The attorney, in fact, isn't. Or the fake attorney, in fact, isn't.
Yeah, well, no, of course not.
Yeah, they're in
Okay.
trouble.
Well, if they know it's invalid. So in my story I don't know, frankly, I think if it was valid when it was executing a ladybird deed to himself, that's
Bad faith.
it's a breach of his fiduciary duty, which makes that transaction voidable. Okay. But the fact that the power of attorney is no good just makes it void. It didn't happen.
Right.
Okay.
No conveyance.
Here's the interesting part. If somebody was going to go after the notary's bond, who should it be?
Does it have to be the
Who was hurt by the way that was
the grandson?
no.
Who?
The son.
Oh, because now that power
What
of
he
attorney is no
expected-
good.
right.
Because by virtue of the notary not doing the proper acknowledgement,
By virtue of the notary not knowing what she could and couldn't do.
he now has a bad power of attorney. But even if that power of attorney were valid, I think we go back to the point it's self-serving.
Well, what's self-serving or
Right.
it's a breach of fiduciary duty,
Right.
there you could challenge it on that part.
Right. I think you got two arguments here.
But I think it's interesting that it wouldn't be the grandson that would have a way to sue the notary, because it'd be the son that had the
Right.
way to sue the notary.
That's correct. Because really, the son is the one hurt in this whole situation.
Because if it was done right,
There'd be no case.
even if they had absolute proof this is what the father wanted, it's no good.
Uh-uh.
I don't think they could ever prove that, because he was kind of 3 sheets to the wind most of the time.
Mm-hmm.
But how are you going to prove it when the only people that were present at that moment in time were the son and the son's wife, and then the notary?
Who witnessed the notary?
Somebody was
witnessed
there.
the power
So
of attorney.
they got somebody.
They
to
had
come
two
in.
people?
Yeah. Well, no, they had the notary and another person.
Okay. I mean, it's sufficient.
It's sufficient.
All right, so let's talk one other aspect about power of attorneys. We have health surrogate power. What's that called?
Healthcare surrogate.
Healthcare surrogate, which is a form of a power of attorney. Yes? No?
Sort of.
Okay. Explain.
Here's the deal. If you have...
Here's the deal. Be careful who you give one to.
Right.
Okay.
Don't give one to me and get sick, okay? So...
Why? What is a health surrogate?
Okay. So you're in the hospital. You've had some kind of an event where you are now on life support, or they've got a vent, and, you're really not conscious. They're just kind of keeping you alive. And they don't really have brain activity, right? So, from a doctor's perspective, what should you do? Pull the plug. Okay? You pull the support and let the person die. Okay? Because that's kind of what all you're doing is artificially prolonging their death. That's all you're doing. Okay? So, medical advice is...
But the state of Florida doesn't necessarily give the doctor a right to do that.
Well, they do, but what's the doctor's concern?
Liability?
To who? That guy's dead.
To the family, I guess.
That's right. So, now, if when my wife had a brain infection of some sort, still don't know what it was, and she was taken by EMS to Baptist South.
Okay.
She does not remember the ride.
Okay.
She does not remember the first 3 days in the hospital. She's completely not coherent. Now, she knew who I was, though. I'm her next of kin legally. Okay. I can direct the doctors, and they're protected by me directing them.
Right. And then we
Okay.
experienced that with Steve Cebulski.
Right.
When he had his accident, we were there in the room, but they had the daughter. He was divorced, so the only
Right.
next person that had the right was the daughter.
Right. Would be a child.
And she
Okay.
made that decision.
Okay.
And they accepted
The
that
concern,
decision.
though, is what if you got 3 kids and they don't agree? Okay. Now you got a doctor's like, what am I going to do? Okay. I know what I know. I know this needs to be done, but I don't want to get sued.
Okay.
Okay. An important thing for people to do is the living will, which is something that says if I am, if the angel of death is sitting there waiting, looking at his watch, let me go. Make me comfortable, let me go. If I have an end-stage condition, persistent vegetative state, okay, and if all you're doing is making it take longer for me to die, which, breathing makes it take longer for you to die, but, we call it prolonging your death, then the doctor can let me go, okay, especially if they can't find anybody.
That's on a living will.
That's a living will. That's what that's for. And you can't hardly walk by a hospital without somebody wanting you to sign one of those things. It's not a do not resuscitate. Okay. If it do not resuscitate, if you sign one of those and it's the doctor or whoever sees it, you get hit by a bee, if all the ground swell up because you're allergic to bee stings, they're not going to give you an epinephrine shot. Okay. They're going to sit there and watch you die.
That'd be like the person we have working in our office that had cardiac arrest. That would be the same thing. If they didn't have do not resuscitate.
If there's a do not resuscitate, then
they would not.
I don't know that the EMS people would have done that. But.
Well, I don't think the EMS people have, but once they got to the hospital,
Right.
If there was a do not resuscitate order, then they would have.
Right. That's why with people who get to the point of having a do not resuscitate, they have it on a form and it's attached to the refrigerator because they will look there.
Wow.
Yeah.
Wow.
Yeah.
Okay.
So just those are powerful documents, but the healthcare surrogate is an important thing so that the doctors have somebody they can feel comfortable listening to. Now, for your spouse, you're already there, but what if you have a spouse and you got kids that are from the spouse and not the person?
Yeah.
Okay.
Well, the spouse has superior rights, I would think.
I agree with you, but who wants to get sued? Okay. Right. Because you see, the husband was wanting the wife to die. Okay. And the kids were wanting the wife to live. Okay. You see what I'm saying? And can you say Terry Schiavo? That was her problem.
Right.
The husband wanted to pull life support, and they were saying, I think it was the parents though, were saying that has ulterior motives or something like that.
Right.
And they had withdrawn support. They had to put support back on her. Okay. They withdrew the feeding tube and stuff, but they had to put stuff back. Now, her eyes were moving and stuff. That's just a reaction the body has sometimes. Okay.
Right.
And after she'd passed away, and they did the autopsy, she was done. Her brain had been gone for a while. So there's no reason to do that.
Okay. So how much does it cost for a healthcare surrogate power of attorney or healthcare surrogate? What do you call it?
Well, if you 62 or over, you can go to legal aid and they do the healthcare surrogate, durable power of attorney, and a living will for free.
Okay. Well, but how much do you charge?
I do those along with estate planning, typically, $500 or less. Maybe
for what?
Maybe some for everything you need.
Tell me what everything is.
Durable power of attorney, will, living will, healthcare surrogate, and also talking about what the right thing to do here is.
For $500.
Yeah. Because we don't make it take a long time, and if you got like a husband and wife, it's coming together. There's a discount for the second one.
Who do you think should have one of these? Everyone, no
yeah.
matter who they are.
Well, okay,
I mean, I'm 57.
I like doing. I do a will because I think you have to do that if you're a lawyer, because I think your certificate will fall off the wall if you tell somebody you don't need a will. But if you and your spouse have children and all the children have the same set of parents, they got the same gene pool, and you want everything to go to your kids equally, that's going to happen without a will. Okay.
But it's good to have a will.
Well, yeah. And again, but a lot of times, remember, we have blended families.
Yeah.
And here's the thing. You got to be careful, especially with homestead.
Right.
Because sometimes the husbands, the thing that bothers me the most is if you have the blended family and let's say the wife dies first and the husband has 3 kids from the wife that they're unadopted children. Okay. He treats them just like his children, but they did not come from his body. They do not have his chromosomes. And then you have homestead and you devise the property to, let's say you got 3 and the wife had 3, you have 2 or 6 kids, and homestead, when it descends as it's supposed to your heirs at law by will or by intestacy, it's protected from creditor claims.
Right.
But if you devise to your unadopted children, you lose that.
Really?
Yes.
I did not know this.
It's a big deal.
Wow.
So I had a case where, and this was, you can't do by trust what you can't do by will. Okay. So, but
if you do a will, does that fix that? No.
If you devise,
Really?
right, to
And you're messing with my world.
a beneficiary who's not an heir at law.
That's right. There's no homestead protection.
Right. The homestead protections go away.
It actually isn't an order determining homestead anymore. It's a program.
Well, you could do an order determining homestead, but
You
it doesn't do much good since you can't say it inured to these descendants out with no creditor claims.
Right.
Because it did not inure to all those descendants because it went to the descendants and or heirs at law and
Interesting.
beneficiaries.
Interesting.
You got to get some legal advice. That's how you prevent these unintended consequences. Because in the case that I had to do,
take care of that. You're going to have to deal with that period. There will be creditors' claims if those children are not legally adopted. Period.
how can you get away from that?
Ladybird deed.
Bingo.
Okay.
Okay. I had to pay.
No, that's a good point.
We had to
Ladybird
pay
deed.
the
That,
Medicaid people $86,000 on a case
why?
because we had a trust that gave it to
Oh, a
all
Ladybird
those-
deed would have fixed that.
a Ladybird deed would have fixed it. Okay. But
Interesting.
yeah. And my guy
Interesting.
that I was working, he bought everybody else out.
Wow.
So, but he got deeds from all of them. But we still had to pay the Medicaid people because that's the law.
Wow.
They're all the children and the unadopted.
The great thing
children.
about coming in for $500 to see you
we talk about
is they're going to talk about that and they're going to get it worked out to where, hey, Ladybird deed will fix this.
Well, the other nice thing about Ladybird deed is number one, they're not on title with you.
And
Right.
you can change your mind.
You can change your mind, but the unintended consequence that they benefit is not only does your real estate taxes not change,
Right.
okay, it doesn't affect your caps or your homestead or anything, but if you had your house in St. Augustine South that you bought in the 80s for $50,000, what's it worth today?
Gotcha. And
Your
you
basis in the
you
house-
still get the step up.
The basis in your house is
Right.
50. If you put your kid on title with you as a joint tenant with the right of
You
survivorship,
have no step up.
there's no step up.
Step up. Explain what a step up is
So
for people who don't understand.
when you die and the kid sells the property, his basis in the property is $50,000. He sells it for $400,000. He has a $350,000 issue to deal with, which may or may not be.
Okay.
If you live there, there may not be a thing. But
Sorry, that's a problem.
if you do a Ladybird deed, it's like he got it from probate court. And,
Right.
and this is assuming all of the assets that moved out to people were less than 14 million. Okay.
Right.
The exemptions for federal taxes.
But again, at the time of death,
it
It's the
steps up.
value of the estate at the value of the real estate at the time of death.
Right. So if it's
Not
worth
what
400 when he
when they
dies,
bought it.
but the person dies and you sell it pretty soon after and
Right.
it hasn't gone up in value,
Right.
then your basis is 400 and your sales 400 and there's no taxable gain.
Right.
Okay. Or even,
Even
if
though you're making $350,000.
no, you inherited $350,000.
I get it. You're right.
Okay.
You inherited $350,000,
And you wouldn't have had to pay a tax on the $350,000.
Right. That's a big freaking deal. If your
It
tax base
becomes
is,
a different. It is a big deal. So that's why.
especially if you do and I don't know how this would work. If you did a deed of joint tenancy with your parent
Mhm.
and you didn't hold title for more than a year, I don't know what that means. If you have joint tenancy,
I think if you get the basis, you get the time. Okay, but I wouldn't.
No,
swear to
I
that.
wouldn't. I'm talking about if you take title as joint tenants rights to survivorship.
Right.
So I don't.
I think
we're
the
talking
the
tax stuff
bottom
we don't
line
know anything
is
about.
Mhm.
a ladybird deed is a great, for most people, it's a great tool.
How much would you charge for Lady Bird deed over and above the $500?
We typically charge $350 plus recording fees for ladybird deed.
So you got $350 plus the $500, so $850, $900 they get out of there with the Lady Bird deed and all their estate work and everything.
And typically we do it as you while you're there.
Yeah, you come in and
It's
and
one.
done on
It's
the-
one stop and one go.
stop shop. Okay. How much would you charge somebody for just the power of attorney? Coming in there, we're going to be out of town. We want to give somebody a power of attorney. How much do you charge for that?
Depends on my attitude for the day, and not very much.
Okay, shoot a number out there.
I don't know, 150, $200,
All
something
right.
like that. I don't know.
We'll say $200.
Because one of the things, okay, you know, it's not, I'm not a vending machine.
I get it.
Because you can get these forms in a lot of places. Okay?
Yeah, but you get in trouble with those forms.
Well,
Okay. The great thing I like about you is that you'll sit down and talk about the specifics of their situation so that the right thing happens.
that's what any attorney should do. Okay.
That's not what every attorney does.
Well, it's what they should do because
They should do, but I know a few attorneys that will make a mountain out of any molehill so
Well,
they can charge accordingly.
okay, and that's,
You're not that way.
no.
And by the way, this show is sponsored today by Rusty Law.
But I ain't writing a check. So
No, the only reason I promote you is because this is serious stuff for my clients.
I know, and it's serious stuff,
I'm
and I
talking
talk
about these
this
things
everywhere.
because I care about my clients and I care about getting my clients taken care of. I want them to know how much it's going to cost, because what I want clients to do is stop showing up with a power of attorney they got offline, not realizing what kind of risk they just put themselves in because of convenience.
And will it work? Okay, that's the key.
Yeah.
Is if you're talking about getting a transaction done, well, if it's if it's acceptable to you and terminates on its own, that's wonderful. But most people need a power of attorney as an estate planning tool. So if they go loopy, somebody can sign their name. Okay, because some people go loopy and they don't die, so we can't do a probate. Okay, we have no way to get something done except to take all of their rights away, and it's expensive and somewhat painful.
Problematic.
And it's people do not like it when we take away their rights. Okay,
So,
they may not know enough to sign their name, but they know that they don't want their rights taken away.
and when it comes to children, though, you don't have any choice. You're not going to be able to have a child because you can't sign a power of attorney till the age of 18.
You can't be bound by a contract, but kids have there's certain ways to take care of kid things too.
Natural guardians.
The natural
As
guardian.
long as it's 15,000 or less, though, of value.
Right.
So that can be a problem.
A kid can.
If a kid inherits a property that's worth $400,000, you're not getting the natural guardian to do anything for them. They're not going to have the power to do so.
Right. Then
So
it would
that has
be
to be a
worthwhile. But
guardianship.
you'd get a guardianship that terminates on its own. But there's a way to take care of that in
Right.
planning.
Right.
And that's by saying we're going to give it to John Smith as custodian under the Uniform Transfers to Minors Act on behalf of Joe Smith.
Right.
Okay.
Okay.
So there's ways to do that.
There is.
And I was happy when I looked at a will that I did that's being probated. And because we knew the kids were young, we wanted to go to them, but we didn't want them to be stuck. So we had it to somebody else as the custodian under that act. And again, Florida supports the ability to transfer title and to be able to get things done without a whole lot of lawyers in the way or court cases in the way. So we have that. And it's also many states have it. That's why we call it the Uniform Transfers to Minors Act, because it goes from one state to another usually. It's just a way to get this stuff done.
What I don't like is when we have parents who will, in an effort to do quote unquote estate planning, do a quitclaim deed to them and their minor kids. They don't understand how dangerous that is. And I mean, what would you say about that? I mean, besides just don't do it.
Well,
because
words mean things.
Well,
they have legal meanings that people don't.
Well, they
take
tie up their property. They're not doing. Now if they get in financial distress and they want to sell or mortgage the property, they won't be able to do that if the value is over $15,000 without a freaking guardianship.
for each kid's interest.
Child, right?
So if you got mom and dad,
if
have
their interest
15%,
is $50,000 each for the kids,
that's
a
a problem.
Do a flipping guardianship, which is not going to be cheap.
It's not, and it's kind of obnoxious. So
yeah,
it's better when it's a kid because we're not taking anybody's rights away.
That's true.
But you still have the reporting requirements, you have the education requirements, and you got to make sure you don't take off the court.
Right.
So when you want to do something, you get permission. And
this is why you come in and spend a few dollars with you, talk it through, make sure that they've thought about these issues. We get people,
and I support people's ability to choose what they want to do, but I support informed choices.
Happens about once a year. We get people in. I want to quitclaim this to me and my son. I'm like, well, how old is your son?
He's supposed to be born tomorrow.
Yeah. And I'm like, well, we'd like you to see Rusty. And then we try to get them in with you. And normally you change their minds. You do trust, or you'll set up a labor deed.
I try to do certain things a certain way that again, I'm trying to prevent unintended consequences.
All right. We're short on time. I want to bring up one more thing. What would you do if you have a foreigner who is married in a different country, legally under the laws that that country abides by, moves to Florida, and the spouse is 14 years old?
Is that
for our next show?
Well, okay.
I don't know if we're going to talk about it today. How about that? We'll talk about that.
How about this? What if you have somebody from the Middle East who is Islamic and has 3 wives?
And they move to Florida. Wow. All right. We're going to say that for next week. This has been Land Title Talk. We appreciate you listening in. Cliffhanger, yes. And we'll be back next week. Remember to like and subscribe on our YouTube channel. We really appreciate when you do that. And for listening, I'm Steve Collins from Land Title of America. We've been in the title industry, title business since, 1997 when I opened Land Title of America. But I've been in the business officially since 1991. That's when I started getting a paycheck. But I actually been meandering in and out of the title business since 1985, I think is when I really started working there. Rusty's been in it for a million years, but we've been around for a long time, and we're able to take care of your special title needs and your basic title needs. So always keep us in mind. You can reach us at 904-797-9600, 904-797-9600, or you can reach me on my cell phone, which is 904-501-4481, 904-501-4481. Love texting. And you can reach Rusty at
904-829-6600. With any luck, my legal assistant Ben will answer that way, because if I gave you my phone number, it'd be forwarded to that number. So
yeah, so you can call him at 904-829-6600. And Julie, thank you for always being with us. Appreciate you keeping us in line and looking up information for us. This has been Land Title Talk, if I can speak English, and we'll see you next week. Thanks.